there's a lot of flexibility with the E2. One of the big changes that have happened in the past year or two is that the spouse now has unrestricted work authorization at the time of entry.
They don't have to wait like what, 3, 6, 9 months to get the employment authorization card?
Exactly. So that's a really big key. So the E2 treaty investor is only allowed to work for that treaty enterprise, but the spouse has unrestricted work authorization, can start their own business, can work for any US employer without any further sponsorship.
We've seen,
it is a very,
on that point, we've seen an increase of Visa franchise clients where it's like a data architect, a software engineer, and a petroleum engineer was in our office last week, where the E2 Visa, you get that for the family, and then the spouse gets a job. And maybe, in Colombia, they're making 30, 40K a year. In Houston, they're making 150, 200. So the E2 Visa business, there's not as much pressure to perform that first year, that second year. You can take some time because you also have the income coming in from the employee. And then if they like the employee, we've seen the employer sponsor them for an EB3, EB2, all different types of green card categories.
one of the big things that clients always need to be reminded on is the difference between a visa and status.
Definitely.
And a visa is really just the ability to go to a port of entry and make an application for admission. Status is your actual immigration status that you have in the United States when the officer at the airport stamps your passport, or if you're in the United States and you do a change of status or an extension of status. And with the E2, depending on what country, but the maximum is up to 5-year visa. So you don't have to go back to the consulate and get a new visa. You can travel in and out of the United States with that visa during that 5-year period or whatever the validity is on that visa. But every time that you come in, you would have a maximum of 2 years of E2 status in the United States. So, if you travel in and out, every time you come in, you get a new 2 years of status. If you don't want to travel, then you need to file for an extension of status before it runs out. And that's something that you'll have to work with. You would work with us, and we have automatic calendar reminders based on when you enter and things like that. But it's something that you are responsible for, and every individual and family member is kind of working on their own in that regard. So a father comes in and out, but a child stays here. Well, the child may need to do an extension of status if he's not traveling in and out of the country too. We've had that happen, unfortunately. But there are lots and lots of advantages, and that's why I think a lot of people do the E2 in particular. If you don't spend time in the United States, I'm not a tax professional, but there are ways that you can avoid taxation on your worldwide income if you're not considered a US person under the substantial presence test. Again, talk with your international tax advisors on that.
We've had clients give up green cards because they have a significant inheritance abroad. And it's like they just don't want to pay taxes on that inheritance. God forbid they die or when they pass away. So they give up their green card and do the E2. But yeah, you definitely need a tax advisor. And again, like you get what you pay for. So right. you could be saving millions of dollars, and the thousands of dollars that you pay for the attorney are generally going to be worth it.
A lot of folks use E2 as a short-term non-immigrant visa strategy to enter the United States in a quicker way than waiting for an EB5 case to be approved. And in particular now with the new EB5 rules where you can do an adjustment of status based on a pending I-526, we're expecting E2 to become a lot more popular in that regard. And it's not just EB5. Patrick and I were talking about how in particular for those from Latin American countries, EB2, EB3, this is a nice way to get to the United States quicker and then go through the green card process. Of course, you do have to have the intent to depart upon application and at the interview and when you're making your entry with the E2, but circumstances can change. And it's interesting, in the Foreign Affairs Manual, they say you have to have your intent to depart, and certainly that's what we advise, but they also say in there that you can sell your home in the foreign country and move here. And so it's a little bit of a quasi dual intent type visa. It is something that we are very careful about, and you need to have very good immigration counsel on this, because the last thing that you want is any sort of claim of misrepresentation or visa fraud coming in on a non-immigrant visa.
Do you feel it's more credible, or you've seen it's more credible, like going E2 to EB5 versus like someone studying an English course and getting an F1, then switching over to EB5?
Yeah, I think, there's the 30-60 day rule for USCIS, the 90-day rule for the Department of State. We're very conservative on this. We certainly want folks to follow the rules of the US immigration laws. I would think, though, in your example, yeah, it is a little bit, I think, less risky to kind of come in on the E2, as opposed to, are you really a bona fide student if you're coming in just to do an English course and then 60 days later you file for an adjustment of status? I think that has some possibilities for some red flags there.
Yeah, we've seen a lot, especially Brazilians playing that game where it's more of a tax play, where they're doing the F1. They're here for 4 years doing some kind of course that they're not actually interested in, and then it comes time to switch over. And I'm sure that can kind of raise, some flags.
And it will.
Yeah.
You can be sure of that. It will raise the flags.